Asiam na siaya. Ainta pekwalalton tanis na nemoch ait na squalunen. Konas heit sepka siamastimoch. Good morning, everyone. My name is Doug White from the Nanaimo First Nation. My new channel name is Cleishan. My co-Salish name is Kwalasalton. I want to thank the New Relationship Trust for the invitation to come and speak on this important issue. I understand I was asked to talk about the issue of consultation and accommodation and where that particular issue is at today. So I think everyone understands that we're in a moment of great uncertainty, of significant transition, that with the impact of the Tsilhqot'in decision, the impact of the firm, unqualified endorsement of the UN Declaration on the Rights of Indigenous Peoples and the embedded concept of free, prior, and informed consent, with the unfolding and the conclusion of the Truth and Reconciliation Commission, that we're in a very critical and defining moment in the progress of the relationships between Indigenous peoples and non-Indigenous peoples in this country. Now, this issue of consultation and accommodation has been a very important precursor or development to this particular context that we're in. I want to acknowledge Miles Richardson, that's here with us today, from the Haida Nation, the work that they did when they stood up those years back now to say that the idea that the Aboriginal title of the Haida peoples doesn't matter, that it does not in any way at all constrain Crown behavior, that is wrong, and that they fought that idea all the way up to the Supreme Court of Canada by 2004, resulting in a decision that has profoundly shifted Crown First Nations relations. It was a remarkable achievement. And it brought Indigenous peoples into the room in significant ways with respect to the politics of decision-making in this province, in this country, with respect to the economics. Now, I'm going to talk a little bit about that overall trajectory and go a little bit deeper in history in British Columbia to talk about the trajectory or the arc of the relations between the Crown and First Nations and how it's moved over the course of the history from the mid-19th century through to today, to talk about and understand a little bit more about where we're going, what the future should look like. So I put this presentation together. I've got a couple of documents here that I want if one of the organizers can help distribute some of these documents to the attendees. There's when I was on the Leadership Council a number of years ago now, there's this bit of work that we did collectively with the First Nations Summit, the Union of BC Indian Chiefs, and the BC AFN. I led this work because of my experience when I shifted out of being a lawyer. I was working at Mandel Pinder downtown here, and we tragically lost our chief at home. And I was asked to go home to do that work in the Nanaimo at Nanaimo. And being in the role of leadership and in that specific framework and the way that you're positioned to see things, I think much more clearly, I have to share with you, I was absolutely shocked and stunned at the depth of the continuing denial of the Crown for the legal rights of our peoples. I don't mean any disrespect to the leadership of my nation, but we were getting steamrolled and pummeled by the Crown with respect to decision-making in our territory. And, Nanaimo it's got a couple thousand members. It's in an urban context. It's got 75 staff. When I showed up as chief, there was 7 or 8 different law firms advising the nation. And we were in a very weak position with respect to Crown decision-making. It was hard to grapple with, hard to see. It was upsetting to me. as I shifted from, for those 4 years that I was chief at Snuneymuxw, for 3 of those years I was also on the Leadership Council of BC. I was asked to run to be one of the leaders of the First Nations Summit. And in that way I had that kind of responsibility to be attentive to the issues of all of our nations. And the experience I had at home really made me think about, if Snuneymuxw is struggling in this way, I assume that many First Nations are struggling in this way across the province. That we need to do work collectively to think about that. Why is that so? How is it that when we're engaging with companies, we're engaging with industry, and engaging with the Crown, that we're only looking at the crumbs of the economic activity and reality that are being discussed, that are being apportioned and shared? That the substance, the subject matter of our relationship to our territory, like the forests of Haida in Miles's case, that subject matter is being handed over, or has been handed over to others to derive significant economic benefit from, and that our people are being left in the dust, notwithstanding the Haida Nation decision. So seeing the challenges and trying to understand them and flesh them out, trying to create a broader shared understanding, led to this work that produced this book. Now this was published in 2013, and it goes through a whole range of different issues. I know that there's going to be another 35 of these will show up sometime this morning. The First Nations Summit is sending them over. They're to Veronica's attention. So if you haven't received a copy yet, make sure you grab one during the day. And you'll see that it goes through a full scope of the issues about consultation. It talks about and begins with a number of, there's about 6 different chapters that cover everything from Indigenous legal orders, the development of First Nations policy, the common law perspective, international law perspective, referencing the UN Declaration, and then provincial policy and federal policy, and pure economic policy. There's so many different elements and dimensions to this work. And in this short, brief presentation, about 45 minutes or so, I want to cover some of the key issues that we saw them as they were at this particular period in history. Then I want to talk, though, and I want to shift into a discussion about the implications of the Tsilhqot'in decision on Aboriginal title for this work. Because in this work, we talk a lot about what we see and how we think that things should start to shift towards consent. But we did not have the Supreme Court of Canada's Tsilhqot'in Nation decision from the summer of 2014 when we published this work. It was before that time. And I think that it's important for everyone to continue to understand and know how transformative and important that decision is in terms of breaking the status quo and upending the last 100 years longer of provincial and federal law and policy with respect to your territories and decision-making about your territories in a way that presents significant opportunities for all of your nations. So I'm going to talk a little bit about this book to talk about that second part of the implications of what the decision means for nations and for the Crown and industry. I'm going to make some reference to this paper, this document that I authored with Dr. Roshan Danesh. The two of us wrote this on behalf of and through a partnership with the First Nations Forestry Council. Keith Atkinson, who's the CEO here, asked us to get this paper together. And what this one is about the implications of Tsilhqot'in for all of the stuff that we're talking about. Understanding, and we'll go through this a little bit, I want to share with you the basic premise of this particular sector as a model and an example that I hope will show and illuminate some of the basic principles of where things need to be moving. And in that work, we talk about what are the Crown's assertions about ownership and jurisdiction over our territories and over the landscape of Canada, British Columbia. What is the Aboriginal relationship with those same spaces now informed through the Tsilhqot'in Nation decision? And then what are the implications of that? So that in the course of this presentation, we'll be covering some of these. That's the basic framework. I might say a word about veto as well, because that seems to be the rhetorical boogeyman of the Crown. But it gets to the issue of who has authority to make decisions. And I think it's I'm going to go to a slide. We'll see a slide in a minute where I can talk about that in some level of detail. But in terms of the background to Crown First Nations engagement, it's important just to keep in mind that at the core, what the main issues are that are engaged when we're talking about this issue are the questions: who owns the lands and resources, and who can make decisions about these lands and resources. Those are the two basic components: ownership and jurisdiction. On our side, of course, we've, since time immemorial, going back thousands of years, we've had important real legal relationships with our territories. We have our own systems of law, our own Indigenous legal orders and traditions that reflect that reality. Since 1846, we have, under the Canadian common law system, Aboriginal title with respect to that landscape. Those are the Aboriginal title of your peoples as a matter of law arose and crystallized in 1846 in British Columbia, the time of the assertion of Crown sovereignty. It's there. It's always been there. It does not need a legal decision for it to exist. It does not need a treaty for it to be recognized, for it to exist. Legal decisions and treaties don't bring the Aboriginal title of your nations into being. They simply clarify the boundaries, the location, and those kinds of issues. But they are not the source of your title. The title that was recognized in the summer of 2014 had always been there since 1846. It's going to be important as we move through and discuss. Now, the Crown, for their part, you see the second map. This is British Columbia here, but this whole area here between the British and the Americans was mutually referred to as the Oregon Territory or country. And it wasn't until 1846 that they decided between them the boundary along the 49th parallel, and that Vancouver Island would stay with the British. So the Treaty of Washington from 1846, or the Oregon Treaty, is the moment of the full assertion of British Crown sovereignty. So they claim ownership over the lands and they claim jurisdiction over them. Those are the two basic components of sovereignty at international law. That there is a people that have the right to self-determination, and that these people have a special relationship called territorial sovereignty with a certain part of the face of the earth. So those two things don't line up very well together. The fact that we exist, and then more recently the Crown's assertion to have ownership and control over these lands. In the early part, from 1846 to about 1859, it's important to reflect upon the early model of Crown First Nations engagement and relations. There's a brief period of recognition. This is the time period of the Douglas Treaties on Vancouver Island, the pre-Confederation treaties over there, 14 treaties from 1850 to 54, that were founded around the basic principle that there could be no settlement on Vancouver Island, and there could be no resource development on Vancouver Island by the Crown without the consent of Indigenous peoples. This was not a controversial issue or idea of any kind at all. The treaty where I'm from, in Snuneymuxw, from 1854, it was the last one that was signed. It only exists because of the clear recognition that the Crown required an agreement or an understanding with the Snuneymuxw people prior to making use of the coal resources from Snuneymuxw territory. They realized and discovered that there was coal in our territory. They wanted it. They spent a couple of years working to negotiate with my people a treaty that gave them permission to come into Snuneymuxw territory to buy coal from us. Another important principle is just that I wanted to share was just simply that the relationship was very much nation to nation and very much grounded in the principle or the idea of non-interference, that the Crown would not get in the way of the continuity of the Aboriginal reality. After 1859, there was a decision made to shift away from that particular approach. And it was during that time that the groundwork or the foundation of this miserable relationship that we've had ever since was laid. The basic idea that it's premised upon were that, Aboriginal title doesn't really matter. We don't need to pay attention to the Royal Proclamation or all of the basic law and policy that led to the treaties on Vancouver Island. We can toss all of that out. And there's just a pure assertion of Crown ownership and jurisdiction. Now, this is the law and policy that prevailed until 2004, the Haida Nation decision. We've got to keep in mind that from 1859 to 2004 is a very long period of time. Very deeply rooted ideas and patterns of behavior. When we talk about the status quo in British Columbia, when we talk about trying to overcome the inertia of the Crown, shifting, why is it so difficult for them to shift and move? Why is it so difficult for them to show some respect for our Aboriginal title and rights? It's because of this. Because the whole fabric of British Columbia, law, policy, society, is built around the ideas that we don't matter to each other, that Aboriginal title doesn't matter, that the Crown doesn't have to show any respect to it at all, that the Crown owns the land, that the Crown has the jurisdiction, and that they are wholly unconstrained by anything. Aboriginal title does not get in the way of them. Aboriginal peoples do not get in the way of Crown decision-making about the landscape of British Columbia. Aboriginal title does not get in the way of the Crown apportioning the resources of British Columbia to third parties. If we want to create a tree farm license to most of Haida Gwaii, we will do that. If we want to hand that tree farm license over to Macmillan Bloedel, we will do that. The Haida peoples have absolutely nothing to say about that. So a very long, deeply rooted pattern that the Crown continues to cling to. I'm Then we get to the Haida Nation decision that really brings into sharp focus in 2004 some of the statements that had been made in Delgamuukw and in other places in Garin, Delgamuukw. Sorry I didn't give recognition, respect to my Coast Salish relations over here, Musqueam, Squamish, Tsleil-Waututh. This is in the context where Aboriginal title from the late 60s, early 70s, 1973, the Supreme Court of Canada made the decision that, you know what, Aboriginal title actually does matter in some way. We don't know exactly how, and we're not going to make any legal declarations about it, but as a legal principle and theory, we're willing to say something about it, try and shift relations. And so you remember the ultimate, one of the ultimate manifestations of this age of denial was in the White Paper in 1969. So 110 years after BC firmly established the pattern of denial, it achieved one of its ultimate manifestations in 1969 federally with the White Paper. And the White Paper is premised at its core on the idea that the federal government's conception of what this country should be in the future does not include Aboriginal peoples having different rights from other Canadians. And it was here in this city, Trudeau was out here in that time period, and he talked about treaty rights and Aboriginal rights as historical might-have-beens. I don't know, whatever was going on back in the mid-19th century, the 1800s, I don't know. I don't know why they would have done Douglas treaties on Vancouver Island. It's not part of my vision for what this country should be. That isn't a proper, just, liberal society. We can't have some aspect of Canada having different rights than others. And so, the White Paper in '69 was really a clear statement of this basic underlying policy and mythology of the Crown. And, oh, my thing's broken. There it is. So, we had, to his credit, and after the Calder decision, this litigation that broke that policy effectively, Trudeau admitted that he was wrong. Well, I was wrong. I guess these rights do matter. And that's where that became the beginning or the foundation for the comprehensive claims policy in Canada, where federally the federal government said, we will sit down and negotiate to seek to resolve the issues of Aboriginal title with Aboriginal peoples in the country that we don't have a treaty with yet at this point. And they began the negotiations with the Nisga'a, negotiated bilaterally for 20 years until the province joined. But there was an important shift, a pushing from the legal decision pushed the Crown into a different pattern of behavior. Good morning, Michelle. And that was an important, a critically important background to development to the stuff that we're talking about today. We have to always think about and see and learn how to make use of the legal process and the courts, and see how it does or doesn't change Crown behavior. We see and understand why didn't the legal process in Canada provide any Aboriginal title remedy to First Nations until 2014. Why? Because there had been a comprehensive claims policy process set up. There had been, in BC, there had been treaty negotiations process set up to deal with these issues. And courts were loath to make decisions themselves if there was a real, legitimate, valid political process. And you see in all of those decisions and all of the judicial behavior in trying to find reasons or ways not to make decisions, they bent over backwards, got involved in all kinds of judicial acrobatics to not make a decision in Calder, to not make a decision in Delgamuukw, to always avoid making legal declarations. Because as late Justice David Vickers said in the trial level decision in Tsilhqot'in Nation, the basic belief was that the court system, the legal process in Canada, in his words, is ill-equipped to deal with the complexities of these issues. And for God's sake, go and sit down and sort these things out. The proper space for resolving Aboriginal title isn't in a courtroom. You go and sit down at a table, nation to nation, and talk and resolve and negotiate the complexities and the nuances that we can't address and deal with in the court system. So the courts originally had a lot of faith in those political processes. But this, I think, this was the beginning of the breakdown in that belief, was the Haida Nation litigation and the basic facts around that. Because, of course, what was happening was the Haida Nation was sitting down with the Crown at one table to seek to resolve and talk about and negotiate around the Aboriginal title that they have. They were sitting there looking at the landscapes of Haida Gwaii. At another table sitting over here, the Crown was sitting down with industry. And they were saying to industry, we're going to renew for another quarter of a century your tree farm license. To the very same stuff that they were negotiating about with the Haida people. At one table, they were giving away to industry at another table. The Haida people stood up and said, what is this? This can't be right. This can't be just. The Crown's view was that Aboriginal title doesn't matter. They won't be constrained unless there's a treaty or a court decision or some kind of a legal declaration. Nothing gets in our way of us making full use of our ownership of the Crown lands of British Columbia and our jurisdiction over those lands. And so, yes, we can sit with the Haida over here and negotiate with them about that stuff, and at the same time, we can hand it away to Macmillan Bloedel. The Haida didn't agree with that, and they went all the way to the Supreme Court of Canada to get that issue resolved. And this was the first remarkable shift out of the age of denial. Because what the court said to the Crown was that you cannot just carry on like this stuff doesn't matter. You cannot continue to act in a way that completely denies Aboriginal people's relationship to their territories and to their views about how their territory should be used. And it talked about, though, what is the foundation for this shift or this difference? Where does this come from? And they talked about the honor of the Crown as a source for driving something different. It's not this is important to keep in mind, and it'll become clear when we move through this. It is not the specific reality of a need for an Aboriginal title to unfold as it should, or for Aboriginal jurisdiction and decision-making to unfold as it should, that gives rise to a duty to consult. It's all within the Crown itself. The honor of the Crown is the source of modifying Crown behavior from Haida Nation. And what it said was, it said that when the Crown made that assertion in 1846 of sovereignty over Indigenous spaces, it put itself and assumed a specific kind of relationship with Indigenous peoples that manifests in different ways in different circumstances. And they said, we know from Garin that with respect to specific kinds of rights or interests, that sometimes that relationship manifests in a specific fiduciary duty on the part of the Crown. That if we know that if there is a legally established right that the Crown has assumed discretionary power over, that brings them, because of the honor of the Crown, into a fiduciary position with respect to those rights and those peoples. What they said, and what was different and new in the Haida Nation decision, was they said, what do we do with those circumstances where we do not yet have the level of specificity about rights, like existed with the Musqueam people in Garin and their Indian Reserve land? What could we do? What does the honor of the Crown require with respect to First Nations and Aboriginal peoples that only have merely asserted rights? They're saying that they have an Aboriginal title, but we don't know that they do. We assume they have some, but we don't know where. We don't know how expansive. We don't know if it exists in this particular location. What do we do in those circumstances? And they said, well, in that particular context of undefined, unspecific rights, the honor of the Crown doesn't give rise to the high standard of a fiduciary duty, but it does give rise to a duty to consult and potentially accommodate Aboriginal peoples with respect to those kinds of decisions that might impact upon those titles and rights. Now this last point here on the slide, Crown ownership and jurisdiction still prevails. I think this is something everyone in this room understands very clearly, that notwithstanding how profoundly this decision has changed our relationship with the Crown, we are still very much in a model that is premised on the idea that there is only one decision maker in British Columbia, and that is the Crown. There is only one authority and there is only one jurisdiction holder. That is the Crown. And that as part of their decision-making about the Crown lands of British Columbia, they have a duty to consult. You go and talk to the Indigenous peoples, find out what they're concerned about, find out what their views are, see if you can mitigate, see if you can accommodate. But end of the day, it is crystal clear whose decision it is to make. And that is, it is the Crown's. Now, the Tsilhqot'in Nation decision, and this is where I want to start to talk to you a little bit about the significant, now this is like sort of the next step, the next major transformative moment in this particular, the Crown First Nations relationship. And so what happened in the decision? 2014. Why did the court make the decision? It's important to know that the Crown had refused to make any kind of an Aboriginal title legal declaration for 4 decades. Well, why now? What changed? I think it's partly informed by things like the Inter-American Commission proceedings of the Halkamenim Treaty Group that went down to Washington to talk to the Inter-American Commission about the fact that we believe that it offends the human rights of the Halkamenim Treaty Group peoples that we have no way within Canada to have our Aboriginal title demarcated and recognized. Canada came back and pushed and said, And you know what? You don't even have a right to be here. You have no standing at international law to be in this forum because you have not exhausted your domestic remedies. So Hulkaminam peoples, you should go back home now. Be quiet. The Hulkaminam peoples and First Nations across the country put forward friendly briefs to the Commission to tell the story of the potential domestic remedies that Canada had talked about. Because Canada said, they said to the Inter-American Commission, they shouldn't be here because they could have been in Canada in the court system seeking to have their title determined, or they could have been in the treaty process in British Columbia. They could, which they were, of course, but they said they could continue and carry on in the treaty process in British Columbia to get their title dealt with. Excuse me. And so everyone, First Nations across the country, put forward the stories about the legal process for the past 4 decades, and also about their experiences in the treaty process. And of course, they told the story about the legal process, that after 4 decades, tens of millions of dollars, that there was never a single judge, not one decision that had ever made a legal declaration about Aboriginal title. Not one. They said the treaty process, for its part, requires First Nations to set aside their title and take something different in its place. A fee simple interest is the mandate that the Crown has come forward with. And that notwithstanding the fact that it has worked for a number of different First Nations, broadly speaking, it is not working, and it is not a path to have Aboriginal title recognized. And so, in a very embarrassing decision for Canada, the Inter-American Commission issued that procedural decision on standing, and they agreed with the Hulkaminam peoples. They said the Hulkaminam peoples are able to stand here in Washington in front of this commission to talk about the human rights violations of Canada because there are no effective domestic remedies in Canada for Aboriginal peoples to have their title recognized. The legal process has never provided a remedy from going back to Calder. And the treaty process, and they agreed and understood that the treaty process was not a pathway to have the title established either. So there was that embarrassing decision, and then there was also the very horrendous and embarrassing decision of the BC Court of Appeal in the Tsilhqot'in Nation decision itself from 2012. A horrendously racist restatement of the policies and ideas of denial from the late 1850s, early 1860s. You remember the Groberman's conception of Aboriginal title, fully and confirming the provincial arguments about what Aboriginal title is. Because after the Calder litigation, when they were forced to acknowledge that, okay, maybe Aboriginal title does matter, instead of just outright denying it, they sought to denying it by minimizing it as much as possible. And so in 2012, absolutely remarkably, we have a unanimous BC Court of Appeal bench that actually says, Aboriginal peoples, if you want to find your Aboriginal title in this province, then when you're fishing, you should look down at your feet if you're fishing on a river. You look down at your feet and you look at that rock you're standing on. That's the extent of your Aboriginal title. Don't come to us and talk to us about mountainsides and massive valleys. That's not what Aboriginal title is at all. You know, the small spots theory that the Crown was advancing about title. For God's sakes, I guess if we have to acknowledge title exists, okay, it exists, but if it does exist, it only exists in very small, intensively used spots. And so the message in 2012, just the other day, from the BC Court of Appeal was, you know what, you should probably just go back, go and sit down on your reserves. Stop talking about this title nonsense. That's over, it's past. Your reserves are probably bigger than any Aboriginal title you'd be able to prove in court. This discussion is over. So in 2012, we effectively had a very similar statement that the great Squamish leader Andy Paul and the Haida leader Peter Kelly got in 1927 when Canada invited them out to Ottawa to talk about these issues. They told the history and the story of the Crown First Nations relationship to that point in time, talking about the treaties on Vancouver Island and the continuing reality of Aboriginal title, the Indian land question. They articulated it. They advocated around it in very powerful ways. 1927, the response was, it wasn't, okay, they've come out, they've told us that there's some really serious outstanding business in British Columbia that for some reason was missed or left. Geez, we better grab a hold of that issue and start dealing with it. That's not what they said. This joint committee, the Senate and Commons, they got together, they talked, and they said, oh, for God's sakes, I don't ever want to hear any Aboriginal person ever come here again and talk about these issues. What was that? Let's amend the Indian Act to make what they just did a statutory offense. We'll send them to jail if they ever try and talk about this nonsense again. So, 1927, advocating about Aboriginal title rights was effectively criminalized. Then that was dropped in 51. Then the whole era of litigation opens up. White and Bob, Calder, all the way through. We get to 2012, the end result. A unanimous bench of the BC Court of Appeal is effectively the same thing that was said in 1927 in Ottawa. Amazing. We have to understand the challenges that we're facing. 10 minutes? What time is it? So this brings me to like this slide, which presents sort of a schematic, a really rough sketch. It oversimplifies, but it talks about the basic trajectory of the issues that we're dealing with. So this is the denial period, right? Up to 2004. Unconstrained Crown authority. And this is the Crown stream. This is the First Nations. No Crown recognized First Nations decision making. Haida Nation comes along in 2004, creates a rupture that leads to the duty to consult. The duty to consult has been profoundly beneficial to our peoples because it gives us a toehold. It gets us in the room. It creates some leverage. For the first time, people have to pay attention to what our views are. Also in 2007, the United Nations Declaration comes and the free, prior, and informed consent principle is created by the nations of the planet. But Canada endorses it in a very limited way. They put a lot of reservations on their endorsement. Then we get the 2014. This is the big rupture that breaks with that tradition of denial, that breaks with the courts saying we will not make decisions, that breaks with the idea that Aboriginal title is only small spots, that makes clear that Aboriginal title includes the full beneficial interest of the land, that makes clear that Aboriginal title includes real decision-making power on the part of Aboriginal peoples. And this is one of the most important innovations, that last point. The idea that Aboriginal peoples have a say about how their territory should unfold. And, you know, don't get me wrong, they still avoided really squarely addressing the idea of Aboriginal jurisdiction. But it's an inescapable conclusion of the Tsilhqot'in Nation decision that Aboriginal peoples have a say. Now, remember I talked about in Haida Nation, the Haida Nation model is that there's only one decision maker, and as part of their decision-making process, you go and talk to the Aboriginal peoples a bit, but you go back and you make your decision. What's innovative and new about the Tsilhqot'in Nation decision is numerous things, but on this specific issue we're talking about is the fact that the court recognized that there isn't just one decision maker anymore, that there is two decision makers. Aboriginal peoples have a say. So it isn't just this honor of the Crown driving or pushing a duty to consult. It's grappling with the reality that how do you function in a coherent way, respectful way, when there's more than one decision maker? The end result and the only possible conclusion is through the principle of consent. That is where consent comes from. Consent doesn't come from the honor of the Crown demanding that the Crown behave in certain ways or whatever. Consent arises from the simple reality of a recognition that Aboriginal peoples have a say. So I want you to look and read. I hope this shows up for you today. This will go through and show you and talk about a number of the different elements. I'm going to pass by this right now. I'm sure you've all heard this kind of stuff a lot of times anyways since the Haida decision. The challenges are that the policies and the approach taken by the Crown, they're not doing this because they've all of a sudden become enlightened or illuminated about a better relationship with Aboriginal peoples. The Crown is only responding to court decisions, and they're doing so in a very narrow and reductionistic way. Their underlying policy is to, as much as possible, preserve the status quo through consultation and engagement, and that their focus is always more on the form than the substance. Let's get together, sit down, have meetings, talk. I mean, you see the idiotic consultation records that the Crown puts together. This is an offensive approach. And that the agreements that result from that pattern in many different ways reflect the status quo. All of the agreement models that exist for the most part are premised on the idea that Aboriginal title doesn't really matter, but okay, if it does matter, then it exists in small spots. Why is there such narrow, miserly revenue sharing models? Why is there such narrow and miserly opportunities in terms of tenure opportunities and resource allocation to First Nations? Why? Because of the policies and law and approaches and patterns of behavior that developed by the Crown during the whole age of denial, premised on the idea that this stuff doesn't really matter. Certainly they don't reflect the reality of the Aboriginal title that has existed since 1846, either with respect to the full beneficial ownership that your peoples have or with your decision making. Come nowhere near meeting the legal standards of UNDRIP. Now, one of the things, what this document talks about and tries to give direction to is the need for a really powerful and comprehensive approach on the part of First Nations to make the most of the consultation and accommodation framework. As I said at the outset, in my experience, even with a larger nation with a big staff, it is a very challenging form of engagement. It's difficult to do this well. Now, this is a key paragraph from the Tsilhqot'in decision, paragraph 76, where they say, the right to control the land conferred by Aboriginal title means the governments and others seeking to use the land must obtain the consent of the Aboriginal title holders. Now, there's all of this talk about justification and infringement. We need to be making clear to the Crown and third parties that the opportunities for justifying infringement of title are extremely narrow and onerous for the Crown to meet, and that they shouldn't worry or build their planning around the idea that, that the infringement of title is going to be a regular element of Crown decision-making and planning. Now, paragraph 92, with respect to how to maximize economic opportunities or how to make clear to proponents of projects what is at issue if they do not have the full participation and consent of Aboriginal peoples to their project, is in paragraph 92 here. It says, if the Crown begins a project without consent prior to Aboriginal title being established. So this doesn't require, this isn't just for the Tsilhqot'in and that aspect of their territory that's been declared as Aboriginal title. This is for everyone in the room. If the Crown begins a project without consent prior to Aboriginal title being established, it may be required to cancel the project upon establishment of the title if continuation of the project would be unjustifiably infringing. So when you think about, you know, the Kinder and Morgan and trying to figure out, should we spend multiple billions of dollars building this pipeline? Or when you think about Petronas in Malaysia trying to figure out, should we spend tens of billions of dollars building this pipeline and LNG plant on the coast of British Columbia? And about the risk analysis that they must do. If you're a CEO advising your board, you're trying to make clear what are the legal risks and what's the opportunity for harm to this company if we proceed on different paths. This paragraph 92 should be front and center of all of your discussions with the Crown and third parties and proponents. That you need to understand that even before our title is determined and established, that if you proceed on the premise that where you don't have our full consent, if you don't have an agreement with us that authorizes this project, if you don't have our consent to it, then we're telling you that we will do what we need to do in the future to protect and uphold the Aboriginal title of our nation. And that may very well include that all of your investment is going to be lost, that the project may have to be canceled if it ultimately is decided that it infringes on our title. And then paragraph 97, this is Justice McLaughlin sort of reflecting on the depth of that kind of uncertainty. What does that mean? Like, this is really breaking the status quo. They smashed it. She said, I add this: governments and individuals proposing to use or exploit land, whether before or after a declaration of Aboriginal title, can avoid a charge of infringement or failure to adequately consult by obtaining the consent of the interested Aboriginal group. So the First Nations response in the months after the decision was to come up with the 4 principles about how the relationship has to shift. And at the core of this is the idea of shifting to consent-based decision-making. Now, the other thing I want you to look at that you have is this. It provides an example of the things that we're talking about with one specific sector, forestry. It talks about the Crown's assertions of ownership and jurisdiction. It explains it. Basically, what it does is it tries to articulate and explain what is the real legal foundation for the forestry regime in British Columbia, and looks and tries to grapple with and understand that. And you will see in this paper that what is at the core, what is the most essential element of the British Columbia forestry regime is not this part, the jurisdiction part, as much as this part, the ownership part. But it's the ownership rights to use and manage the land that is at the core of the BC forestry regime. And then, of course, the paper goes through and talks about, so how does that line up with the reality of Aboriginal title, and what are the implications? This is where it talks about that the the things that are most problematic about the current state of affairs is British Columbia's take it or leave it approach to negotiations, that there are no, for the most part, real negotiations happening, that the revenue sharing is minimal and is based on their idea of small spots that's been rejected, that the revenue sharing formulas are unprincipled and arbitrary, that there's very minimal levels of tenure being offered to First Nations that are not enduring, and that the consultation model that the province pushes doesn't even meet the basic standards of law, and that for all of that, BC expects to receive significant certainty. So the Crown's desperately seeking to avoid consent, and that I really encourage First Nations to work together with respect to ideas and advocacy like the four principles, push and to find ways to move the Crown in a really meaningful way out of this continuing approach of denial. It's still rooted in denial. That we need a comprehensive strategy that includes strong organization at home, in governance, in the law and policy of decision-making and engagement. Crown First Nations engagement for your First Nation has to be rigorous and strong. They have to be able to build capacity and have strong capacity around engagement. That you need strong politics and legal strategies and engagement strategies with all of the various parties that you're engaging with to be able to maximize and to realize the underlying title and rights of your peoples. So I covered a lot of ground, obviously, in very short order, and I've glossed over a lot of stuff, and I've oversimplified and generalized significantly. But it's important to know we're in a period of immense opportunity for First Nations, that if we work together, we will never be in a better position to move forward into a different reality where title is properly respected and implemented. So, New Relationship Trust, Haichka, Haitsepka Siam, to everyone, thank you for your time and attention, and I don't know if there's any time left for questions, but I'll leave that up to chance. A few questions. So if anybody has questions, now's the moment. Thank you. Michelle?
Thanks, Doug. If you could give one bit of advice, and I know that you sped through, so I really would like to hear what you have to say about how can First Nations get ready to be able to receive and work in a place that enables them to work in their territories and receive economic benefits through IBAs or whatever with companies. Like, how can they get ready? Like, what are some of the things that they can do to get themselves in a position to be at that place and space?
Yeah, the getting ready part, certainly having your mind turned toward this issue in a comprehensive way, in a strategic way, is critical to success. You need a strong, comprehensive plan that will drive the work of developing the necessary capacities that you have to put in place to be able to maximize the opportunity. So you need a strong First Nations government. You need strong political advocates that have it clearly in their mind what their object is, what their work is on this matter. Like there has to be powerful alignment between the government. If you have like an economic development arm or end of your nation, then they can't just be sort of running amok, being businesses, right? Because that's important to, I guess, be businesses and go and do what businesses do. But it's important for them to realize and understand that the real opportunities and benefits are going to arise because of the governmental nation reality of the First Nation. And so there has to be a strategic alignment between the governance and the economic development arms. And as a part of the governance is the policy and legal elements of engagement with the Crown. It may be a combination between with proponents. That'll be important too. It depends how you're set up, but get yourself set up, get in a position, equip yourself with the knowledge that's contained from, this is like 6 or 7 different experts in BC developed these different chapters. Gear up for a fight. In my experience, it's important I'll share this. I have never gotten anything for a First Nation of any real value without being in a serious fight, without being in a very powerful position and articulating and using and pushing on each of those streams. You don't get the best benefit just by sitting down and talking to, industry in isolation. You have to be pushing and pressing with the politicians, with the bureaucracies in powerful ways to set the table in the right way. This doesn't happen because anybody wants to do it. It happens because you demand it and you're clear in your own mind what is required for your First Nation. So have that vision, have that all, do the work where that would get you in a position to have total clarity about all of those different pathways and how in the best case scenario they interact and are coordinated and are interdependent with each other. So it's really about planning, being comprehensive, being clear about the interconnectedness of the work to maximize the potential and the value for the nation overall.
Chance?
Sir, back there.
Hi, Doug. One question, Doug, in regards to paragraph 92, ECDEV, I think it is. Can you briefly explain that again? Because in our area, I think that could apply to a lot of the activities that are going on up there with our people in the Carrier-Sickney Tribal Council area. So I'd like to get a little more clarification with paragraph 92.
Okay, paragraph 92. I'm just going to pull it up, and I don't have the presentation up in front of me anymore. But this is the one where it talks about, is 92 the one about the cancellation?
Consent.
Consent, like if no, can someone just find it for me quickly?
No consent, I think it is to permission or someone to do activities in these areas.
Okay, 57. So it talks about once title is established, it may be necessary for the Crown to reassess prior conduct in light of the new reality in order to faithfully discharge its fiduciary duty to the title holding group going forward. For example, if the Crown begins a project without consent, it may be required to cancel the project upon establishment down the road. So what this is about as part of your engagement with the Crown and with industry, you have to be letting them know both what your expectations are and where you're trying to get with them now today, but also be clear and always animating the peril, always articulating and being clear, painting a picture for them about the pain and the suffering and the peril that they face if they do not come to an understanding with your nation. I always say to them, look, we have the highest level of duty as a government to protect the Aboriginal title of our peoples, to protect the treaty rights of our peoples. And if we're not able to do that and achieve that through an understanding and agreement with the Crown and the proponent in this case, then you need to be put on notice that in the future your project will be subject to cancellation. So if you want to go down that road, it's at your total peril. This isn't like a marginal risk of, maybe we might lose 5% is at risk. This is a total risk of project cancellation, which is an amazing thing for me to the only thing you can possibly understand about Kinder Morgan, for example, is that they clearly don't understand that risk, the legal state of affairs. That the Tsleil-Waututh, when they establish their title, that will put them in a position to have that project canceled. So, we're either, that's the transformative shift out of, because the Crown and proponents will always try and cling to the consultation and accommodation framework that's premised on the idea that there's only really one decision maker, and their impoverished conceptions of what title means. So we have to, and this is where, Tsilhqot'in Nation, summer of 2014, The Indian land question was answered. The work of generations of our people, going back to the 19th century. For over 100 years, our people stood up and fought about this issue and made it an issue. The Indian land question. Well, it was answered in 2014. And we have to be clear that this becomes a moment where we have to be in the position of telling the Crown and the world at large what that means, what the world looks like. What is the Carrier-Sakani law about decision-making and how they provide consent or withhold consent from projects? This is our law about this stuff. This is our jurisdiction. We have to occupy the field. We have to have coordinated strategy amongst us to be able to break with the status quo. And so, so that's really where that's the really sort of like a sharp end of the stick of consent is in that paragraph 92. You're sitting down with the Crown and industry and saying, if you're not with us, your project is at risk of being canceled. So you better, if you want to do something in our part of the world, you better understand that reality, and you better start shifting the way that you conduct yourself and start to seek and to operate with our permission, with our consent. So, so that's the really, it's like the hard hitting, it's the one that the Crown is scared of and industry is scared of, is that paragraph 92. It's very powerful for it because it's just the court reflecting on what does this decision mean for how things have to shift and change.
Thank you, Doug. Oh, I'm going to need your card.
Sure. Hugh?
Thank you. I always enjoy listening to your talk on consultation and accommodation. Where it fails me is the on-the-ground reality of denial by the province and what are our options. I like to use the example of BC Timber Sales, which is a Crown corporation, and which looked at Sishot just last year and said, you can prove your village is on the shore, but it's very difficult for you to prove anything inland, and you don't have title established for anything inland. And they will not recognize their duty to consult or seek consent or accommodation. They won't even talk accommodation, actually, even with discussions on consent. So where does that leave us? Well, that leaves us with something between a $200,000 and a $1 million court case. So while I like the discussion on consultation and accommodation from yourself and from the lawyers who talk to us about it, who specialize in the area, very rarely do I hear any option other than litigation or the framework for a plan of how to deal with the continued denial by the province of British Columbia. So I think we'd be well served by that discussion at some future date, given the continued denial by the current Premier and Government of British Columbia. What is our game plan for dealing with that, and how do we get them to accept the Tsilcoteen, the Haida, and all the other cases as well? Thank you.
Thanks, Chief, or thanks, Hugh. That's an important point because, the Snuneymuxw went to the Supreme Court of Canada in 1965, had their decision. They had to go and fight about, is there even a treaty? The issue of the White and Bob litigation was, is there a treaty between the Snuneymuxw and the Crown or not? Because the Crown denied that. As part of their story and mythology of denial, it required them to deny that treaties had been made on Vancouver Island. And so they fought to have that established. When it was established, the implication of that treaty, going back from 65 through to Morrison Olson in just last decade, is that the provincial government has no scope to interfere with the continuity of those treaty rights. So White and Bob in the 60s, the Game Act can't apply. Sanishan Bay Marina, the Claxton decision from the Tseo peoples in the 1980s, the Crown and the land rights that they, like the property rights they offered up to the marina company to build a breakwater in a marina. None of that can happen. The property rights can't exist as a matter of constitutional law because they would interfere with the continuity of the Douglas Treaty fishery. Morrison Olson, same thing about the Game Act. It amounts to a provincial ouster, the Douglas Treaties on Vancouver Island. It pushes back provincial jurisdiction, can't apply to interfere. So that's the most powerful line of jurisprudence that exists in the country. And so in Snuneymuxw, I certainly made use of that because we had a similar situation with BC timber sales. They don't care about First Nations. They're utterly and completely entitled. They're kind of, I think of timber sales people like Parks, BC Parks, separate culture, category of people, the way they think about the world. This is ours. This space is ours. But the BC timber sales, they haven't touched a single stick of wood in Snuneymuxw territory for 25 years. And mostly because of the Douglas Treaty reality. But I share that with you because the Tsilhqot'in Nation decision comes most of the way to the White and Bob principle of ousting and pushing back jurisdiction. And so what's different though, like the division of powers or the interplay of jurisdiction in the Douglas Treaty reality is that, okay, there's the First Nations capacities and their treaty rights. The provinces have no scope to do anything to interfere with the federal government does. And then outside of the Douglas Treaties, but in the general state of affairs across the province, it's always been there's only the Crown. Crown Authority, Crown Authority, Crown Authority can do whatever it wants. And now we've got this new, in the Tsilhqot'in Nation, the new reality of Aboriginal decision making. Now, having said all of that, when I became chief at Snuneymuxw in 2009, 2010, 2 generations after my grandfather was chief during the White and Bob litigation, when I showed up in 2010, the Crown was acting like the treaty didn't exist from 1854. They were acting like the Supreme Court of Canada did not make their decision in 1965. And they were acting like Section 35 of the Constitution doesn't exist. Why were they acting that way? Because they can. Not because they're legally entitled to, because they can get away with it. And so I sat down with my counsel and I said, we have got to figure this out because we have significant legal rights. And we crafted a comprehensive strategy to overcome that denial. And we were very successful. Over the past couple of years, I mean, this is important to know, right? When I was talking in response to Michelle's question, this has got to be like the real work of the nation. It has to be at the forefront of your minds and driving all of the way that, like everything about the nation, the way that you talk in town, at events, at business events, the way that you write to the Crown, the way that you engage with industry, the way that you educate your own people about what your work is, the way that you talk to the public. Like everything has to be lined up behind this strategy to achieve these outcomes. Because, when I've been gone for the last couple of years. I was no longer a chief. 3 years ago, I just came back as counselor. And the Snuneymuxw Chief John Wesley and Council asked me to be the chief negotiator again for the nation of Snuneymuxw. Now, so I show up in my work, and I'm telling you, in 2016, I got to add to the story of Snuneymuxw's relationship with the Crown, not just that they deny the treaty from 1854, the Supreme Court of Canada decision from 65, or the Constitution from 1982, or UNDRIP. They now also are denying the reconciliation agreement with Snuneymuxw from 2013. Why? Because leadership wasn't in their face, pushing and demanding respect for that agreement and for what it means. The moment you take your foot off the neck of the crown, they will fall back to the status quo. And so I'm not saying this is easy. I'm not saying this is clear. I'm saying this is a hard fight, and you've got to gear up for a hard fight. You've got to find ways to motivate the crown and industry to behave differently. You've got to make if they're going to disrespect you, you must make them suffer for that. And I'm not talking about, just at large, the crown, oh gee, the bad crown isn't doing what they should. You have to make the individual bureaucrats and negotiators personally responsible for the disrespect of your title and your rights. Like it's basically all out fighting and war to push and advance and change. I mean, this is more than 150 years of the age of denial that we're still contending with. It is still there, deeply rooted. Even after the Tsilhqot'in Nation decision, you still get people like Jeff Moyes going around talking to the forest industry and saying, from the Attorney General's Office of British Columbia, Jeff Moyes saying to industry, you guys, I want you to know, don't worry about the Tsilhqot'in Nation decision. You stick with us. We'll get you through this. Don't worry. BC Timber Sales, don't you worry about Tsilhqot'in Nation. You still get Richard Fife, in response to the 4 principles I put up there, writing the most ugly racist letter in response to the 4 principles that is just a complete restatement of the ideas from the 19th century that are at the core and the foundation of denial. So this is a real, Supreme Court of Canada decisions matter, but they only matter if you're making them matter. It's because you're doing something about it. So I would just really encourage everyone to really gear up in that way and be attentive or mindful of that pretty grim reality that we face right now. We don't have some enlightened crown and enlightened companies running around the world asking if they can help us implement our title. That's not what's motivating anybody, right? It's just a hard reality. So I think that's it for questions, Chance, and I just want to thank everyone very much for your time and attention. Haida.